Hello YouTube, I am Vince White. I am an employment attorney, and on this channel, I answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Like, subscribe, comment down below. It helps me to help more people just like you. We have a question here from YouTube user Sam Z, who asked us, "Hi Vince, could you please share with us what will happen if I disagree with my attorney on the valuation of my case right before mediation? Or how about when this disagreement happens a month before the trial date? Can the attorney place a lien and remove himself from the case? Then what?" All right. Quick note here before I answer your question. I don't know what's in your retainer agreement, and I don't know where you are. And I don't know the rules of whatever hypothetical jurisdiction you're in. So this answer is going to be a very general notion based on a hypothetical, generally standard boilerplate retainer agreement, which is the retainer agreement I often see, and based on a general notion of the laws of New York State in terms of liens and all that business, fee disputes and whatnot. Okay. The takeaway from that is that I'm giving you general notions and general discussion, not legal advice, and you need to find out what the laws are where you are, and you need to review that retainer agreement you signed to know what your rights and responsibilities are as well. Now, when you review that retainer agreement, don't believe everything in it. Sometimes certain portions of retainer agreements are meant to scare clients more than they're meant to actually bind them. I've certainly seen a number of funny retainer agreements into this channel recently, and I've commented about those in other videos. So your question is here essentially, what should you expect if you're disagreeing with your attorney about the valuation of a case? And I would say to you, first and foremost, the scope of the disagreement is very meaningful here. Right? If you could hypothetically hope to win $1 million on a case, right? That's the most you could possibly hope to win, realistically speaking, right? We can't, these things are not certain, but that's the most you could really hope to win. And even if a jury gave you more, a judge would be extraordinarily likely to knock it down to $1 million. So let's just say that is your hypothetical, right? And your attorney wants to make a demand of $20,000. And you want to make a demand of $800,000 at mediation, right? That's a big disagreement, but the key factor there is that you're still asking for a sum that is not greater than what you could hope to win at trial. Key information there is you're rational, right? You're making a rational decision, and you're choosing not to hedge risk as much as your attorney wants to hedge risk. And listen, I'm being a bit facetious here with the attorney making a demand for $20K. Obviously, if the case, could hope to win $1 million at trial, this demand of $20K might not make the most sense because, that's not a great number. That's an awful lot of risk you're hedging for, unless, maybe the attorney knows there's major flaws with the case and the case is extraordinarily unlikely to win, in which case the $20,000 could actually make sense. I don't know. But you're making a demand that's in the realm of reality. You are operating within the calculations of damages under the statutes involved. You are being rational. You might be wrong, right? You might not be grasping the risk to you or the realities of your situation. That happens. I certainly have interacted with clients who didn't understand the risks of their case and made decisions that I did not feel were wise, right? There's lots of clients who cannot communicate at all, who are like, "I'm going to testify." Yeah, you're going to testify? I had to listen to you about 14 times to understand what you went through. You're not going to get to do that in court. And not for nothing, our conversation was me just trying to get the facts out, for the 14 times. In trial, there's going to be an opposition playing defense and a jury, judge, or arbitrator who's not really listening all that well, right? So, certainly there's clients who just don't get this risk calculation right. But as long as they're within the realm of reality and the calculation of damages, I would say that most attorneys are going to say, "Well, I disagree with you. I don't think you're properly taking into account the risk. I don't think you're properly valuing that risk." But Fine. Your retainer agreement includes trial, if it hypothetically does in this retainer agreement, and I guess we'll roll the dice. We'll see. We'll go to trial if this case doesn't settle, and we'll go and try to win this, right? The other way that could go, right? Same numbers. You could hypothetically hope to win $1 million at trial, and your attorney wants to make a demand for $20,000 still for whatever reason. And always ask why. Ask why. Have those difficult conversations. Why? Why do you want to demand so little? What's going on in your mind that makes you think we should demand only 20 grand? Often, I will be the first to disagree with that attorney, right? Like I don't think that's smart. I think you're undervaluing the case. I think you're too risk averse with this demand, right? So, same facts. You hope to win $1 million. Your attorney wants to demand 20,000, but you got yourself a case of the greedies, and you're asking for 11 billion. And you understand, or at least you say you understand, that you can't win that much. The company doesn't even have that much, right? Can I tell you how many times I've had the conversation with people like, hey, you're asking for more than the entire company's worth. And they look at you like you're a moron. They're like, they'll take a loan out. What? They're going to take a loan for more than the entire value of their company? No, they're going to go bankrupt. Like that. Anyways. So you got a case of the greedies. You're not being rational. You're just way out there. You're asking for 11 billion. Well, that law firm has kind of a different thought process there, right? Like you're specifically going out of your way to tank settlement discussions because you got a mental impairment, right? You're not understanding the way the damages are calculated, even if you're saying you are. Some law firms are not going to take well to that, right? Some law firms are just going to say, hey, that is not going to settle. The number you're demanding is ignorant. It's an ignorant number. It's not supported by the law. It can't really be upheld in court. But we'll try the case. We'll see what happens. Whatever happens. We'll roll the dice. Let's do this, right? Other firms are going to look at that and say, so you are specifically trying to take this case to trial, and that costs these firms quite a bit, right? Like if a firm's, paying your expenses, fronting your expenses, covering your expenses, whatever it is, it's a lot of money, right? So when you do that, you're forcing the firm to spend a huge chunk of money on the case. And some firms are going to look at the case and just say, yeah, this case was a high risk case. And this is like, it's always about the details, right? If you're being offered 60, 70% of the value of a case and the case is high risk, and, some firms are going to get salty that you're demanding more you can hope to win at trial. And they may take steps to protect themselves from that risk, right? Definitely true that the people who don't understand what they could hope to win at trial are often the worst witnesses, right? Or the worst at conveying their story, or just have the least in terms of evidence, right? Their inability to grasp how damages are calculated is often a symptom that also shows itself in their inability to understand risk and their inability to self-audit and understand how they're conveying their story and how they're seen, right? These are all things that travel in packs. These are symptoms that kind of go together. So that's common. You will see firms in that situation take steps to apply pressure to clients or even to part ways with clients. That does happen. I don't think that would generally happen at mediation. I guess some firms might. But the second part of your question is, what would happen if you disagree with the firm a month before the trial date? So here, I would say most firms are going to want to just try the case, right? Why not roll the dice? If they think they can win, they will, right? Most firms. There's definitely firms who just are not set up to try cases. And some of those firms might try to get a little funny with removing themselves from the case and attaching a lien. In terms of the lien, it's going to vary from place to place, and different fact finders are going to see cases different ways, right? A fee dispute committee here in New York might feel very differently about a case than an arbitrator in Tallahassee, right? I don't know. So there is this component of the more work, the more labor, time, investment a firm has in a case, the more likely a fact finder is to uphold their lien on the case. Now, that is generally true, but firms who dump cases because clients won't settle are often not looked upon with a great deal of respect or positive judgment, I guess, from the kinds of folks who hear fee dispute cases, right? They're going to look at that and say, so you took the case, and when the person wouldn't settle for what you wanted to settle for, you dumped the case. Certainly, if that was, that would often lead me to think, if I was that fee dispute person, that this firm's a bit of a jerk. Now, on the other hand, again, we return the idea, if you're asking for more than you hope you can win, right, more than realistically a law would even allow you to win, such that a jury might award you more, but the judge would just knock it down and you wouldn't collect. At that point, you're forcing the firm, who is doing a great deal of labor and investing a great deal of money in your case, to embrace risk that doesn't make sense because you can't come to terms with reality, right? Or there's I'll give you an example. There's people like, no, my Twitter account is going to be huge if this goes to trial. Twitter's not a thing, dude. Twitter's not real. Twitter's gone. It's X now. And there's nobody on it. It's just bots. Stop with your Twitter account, right? Like, firms are not interested in risking 40, 50, 60, 100K for your Twitter account. Or because you can't do math and you can't come to terms with like the risks of your case. Like, there's definitely going to be firms who might refuse to do that trial and might try to fight you for a lien. And listen, those protections are in place because it's very common in this field for this exact for scenarios here. I'll give you a scenario to play out. You had a mediation table. Other side comes to you and say, okay, all right, you beat us up. We'll give you $800,000 in settlement. The exact number that you told your attorney you secretly wanted all the time, right? And clients will hear that number and they'll say, interesting. One moment. And they'll turn to their attorney and say, you're fired. And they'll turn back to opposing counsel and say, I accept. Don't pay him his percentage, right? It's pretty common. And there's definitely a component of like, you idiot. This system was designed by attorneys. Do you think they didn't figure this one out? You think you're the first person to come up with this genius plan? Moron, right? But that's why the lien protections are in place. Because they wanted attorneys. I mean, one, because the system was designed by attorneys. And two, society wanted attorneys to be able to invest time and labor into these cases. And they knew that attorneys wouldn't do that unless the attorneys could hope to collect on their contingency, right? So that's why these lien protections are in place. So, Sam Z, I know I haven't really answered your question. I've given you some loose parameters to think about that might help you to arrive at an answer, what you believe might happen. Generally speaking, if you're being realistic, I would think that most firms should just try that case for you. If you're being a crazy person, and I'm not saying you are, but if you're being a crazy person, people are going to treat you like a crazy person, right? And I mean crazy in the sense of like not disabled in any way, just specifically behaving in an irrational fashion, right? I should pick a better term in the future, but I do want to clarify that. If this video was helpful, like, subscribe, comment down below. Helps me to help more people just like you. Remember, almost everybody works. Not everybody wins. Be smart out there.